meeting of the House Judiciary. We've got several bills I want to announce. So as far as the House Bill 410, which is on the agenda, we're still in the process of getting that bill corrected on a portion of it was left out, we thought, from the original bill, and that will be held over until Thursday for that purpose. So if you're here on 410, there will not be a hearing today on that bill. We're tabling it at the chair's direction. Mr. Holcomb, I'm gonna hold your bill. I'm gonna get myself straight, and I think at first I could. His is gonna be hopefully a fairly quick and easy bill. This is one of the governor's proposals, correct?
Yes, sir.
Have a seat, Mr. Illustration.
Yes, Mr. Chairman.
We're going to be on House Bill 790, which is LC number 411314-EC.
Thank you, Mr. Chairman. Members of the committee, House Bill 790 is presented today as it was introduced to the House. Received a favorable recommendation from Chairman Fleming's subcommittee yesterday in my absence, and I thank the chairman for hearing the bill. Mr. Chairman, this bill results from recommendations made from the Judicial Reform Council, specifically as to procedure regarding administrative judicial proceedings and ensuring that quick and timely resolution to matters are reached. To begin, the members will see at the bottom of page 1, it's beginning lines 21 to 25, with the 30-day time period as a cap within which for to set a specific time period regarding the commencement of hearings as needed. On page 2, and this is I'm looking at the applicable parts of lines 29 to 38. This concerns, and on into the next subpart. This concerns civil penalty proceedings, because currently ALJs have no ability to enforce attendance at the matters, or do not have the ability, as I understand it, to impose penalties, and this would provide some recourse, which, as I understand it, would be ultimately enforced by a Superior Court judge, and that would be through the ultimate circumstances of appearing before the judge, where, just to talk this out, the ALJ imposes a certain civil penalty, it is not followed, then a FIFE could be issued under this, or
by whom? The Superior Court?
Yes, sir.
Okay.
And and so that is my understanding of that part. The timely resolution of matters is what's the objective here, and I know that Whip Coomer served on the Judicial Council that reviewed and approved this. Of the 3 measures that we're bringing before your committee, Mr. Chairman, I probably received the fewest questions or questions about this legislation. Would ask for your favorable consideration. Thank you.
Let me just first delve in, take questions from members of the committee too, but I think one of the big steps we're taking here is to administrative law judge proceedings is in the past, or currently, should they even this time, once a decision is made by administrative law judge, it is to then go back to the department and either the commissioner or director of that department for acceptance of that direction by the ALJ. And he or she can either accept it or reject it as a position to be taken by the department. Is that right?
Yes, sir.
So what we're changing now is the administrative law judge decision is the directive, and it's really to expedite the fact that if a party is, whether it be the state or the other party in that proceeding, is not satisfied with the direction from the administrative law judge, that can be then taken by writ of cert, is it not, to the, or
Yes,
is
sir.
it by, or
Yes,
is it by
sir.
review, just review of the record? What is the way? Review of the record or cert? Review the record, yes, not by cert, okay.
In practice, it's my understanding that many times the department head is simply accepting or following what was previously the recommendation of the ALJ. No, Ms.
Maybe.
Oliver's saying
But
no.
they've also sat on it for long times, too.
But this allows for a more expeditious resolution to get an
Yes.
ultimate resolution of the matter, which is in the state's interest, in the party's interest, and is
Policy interest.
and public policy interest. So, thank you.
Sure is. Are there any questions of Representative Illustration on House Bill 790 from members of the committee? Yes, ma'am. Ms. Oliver.
I was on the commission myself, and the issue of the agency being able to ultimately overturn an ALJ decision is something that we need to be remedied. I'm a little curious about the civil penalties. I don't think that was in the commission's report. Looks like that's new, so that is a good addition in terms of enforceability of the ALJ's rights. I don't see anybody here from the ALJ. From the OSHA.
If I could just take another look at the report and get you a specific answer offline, I will do that.
But there was a lot of good dialogue in the commission about procedures of the 40,000 cases that come to the OSHA.
Mm-hmm. Yeah, they do a tremendous load of work with a small number of people.
And the timeliness issue was real important in terms of moving the cases, because some agencies weren't sending cases over, and that was causing big backlogs.
Thank you. Any other questions of the presenter? Are there others in the audience who would like to address the committee on House Bill 790? If not, we will close off further public comment, and the bill is now in the breast of the committee. The chair will entertain motions. We have a move to pass and a second. Any discussion on that motion? Any amendments proposed? There being none, the chair will call the main question, which is a motion do pass House Bill 790. All in favor of that motion signify by saying aye. Aye. Opposed, like sign. Motion carries. Yes, sir. I neglected to also point out we've got two of our fine Superior Court judges in our audience today. We've got Judge Billy Boyette from, I know, up in North Georgia. Dawson. Glad to have you again, Judge. How's your lamp doing? Okay. I don't know why. She has no good taste, does she? And Judge McGarity, Arch McGarity, is with us today from down in Henry County and environs. Glad to have you, sir. Our next bill will be the House Bill 745, President Scott Holcomb's bill. And let me see what the 410. Okay, it's one we're waiting on. We've had a lot of controversy about this. I want to first talk about the bill, and some people have asked for opportunity to have further public input today, and we will so allow this. This was a bill that was in subcommittee. Although not voted on in subcommittee, we had good discussions, and I mentioned in subcommittee that there were some things I wanted to look at doing. That dealt with the question on the standards by which an individual could obtain the voiding of a lease under a family violence order. And if you look at the paragraph starting on line 13, I'm talking to the committee members now, but we divided this into two areas. One is a civil family violence order, and also then the criminal family violence order. And as to the civil family violence order, we recognize, let me be sure I got the right bill here. I think I got Holcomb bill. Yeah, here's my, please let me call your attention. We've got two bills in your file. The one I'm looking to and addressing right now is LC 297892S, which is, I think has top there, Willard substitute. And what you'll see under looking at really line 14, I'm sorry, as using this code section, civil family violence order means any permanent protective order issued pursuant to Title 19, and of course the permanent order comes after there would be a hearing before the court. And then B is a temporary protective order issued pursuant to the same chapter, provided that it is accompanied by a police report showing a basis for such order. Then you have the criminal family violence orders, as any order of pretrial release issued as a result of an arrest for an act of family violence, or B, any order for probation issued as a result of a conviction or plea of guilty, nolo contendere, or first offender as to an act of family violence. And then we have a definition of family violence, which is located in another area of the code. The thing we're doing in this bill, which is a somewhat unusual step, is we're allowing for the cancellation or voiding of a contract between the person who is the victim in a family violence and the third party who is not really associated with anything that's happened relative to the question of the family violence matter. And I felt there had to be something further than just a ability of individual going in as the alleged victim and taking out a affidavit and getting a temporary order issued, and then use of that temporary order as a way of voiding the lease. And my feeling was, since you're having a third party who is the one who will be financially harmed, at least there'd be something done as far as another measure of proof, and that would be, to me, the only other thing possibly available would be the police having made some investigation and come to a filing of a incident report showing that there was a report of active family violence involved with it. So I have unilaterally, you might say, looked at the need in voiding this agreement between at least two parties as having potential need to at least be sure it's not being misused. I'm not accusing anybody of being wrong about doing this, but I'll say from the years of practicing law, I know sometimes people will testify something when there's a need and a means to be achieved, or there's a financial issue involved. So I just felt there was a policy need here to have the matter addressed with regards to some other proof that there is, in fact, this type of family violence situation occurring. I have opened it up to further public comment. I don't have my list in front of me. Julius, do you have a list over there next to you of individuals? Would y'all pass that up to me? I didn't realize that's not here yet. Thank you. Elisa, I'm sorry I can't pronounce your last name. Barris. I'm way off, but I'm sure. Please come up.
Where shall I sit? Over here?
I'm sorry, up the directly in front of me, if you would. If you'd introduce yourself to us and tell us if you represent an organization.
Sure, thank you.
Pull that mic around where you can hear. We can hear you clearly, and whoever might be watching.
Is this better?
That's much better.
Okay. My name is Elisa Covarrubias. I am an advocate for victims of domestic violence. I've been doing that work for about 12 years, but I'm primarily here today as a survivor because I had a personal experience in which my then partner did physically assault me, and I wasn't able to get out of my lease or even to move to a different unit in the building for safety reasons. So I'm here in support of HB 745 as it is currently, without any additional burden on the victims. We encourage the committee to support the bill with the current requirements regarding a court order as documentation for terminating a lease early. When a person comes to apply for a protective order, there is a process for it. And many times a victim is not even able to obtain a police report the first time they call. As a victim advocate, one of the things that I get to do is to accompany people to law enforcement to make reports, because a lot of the time they show up to the temporary protective order office, and even though they've called police, they were not given the option to obtain a report at that time. And speaking from personal experience, I did also have trouble making police reports many times, unless it's to a degree where there's some kind of physical injury. A lot of times it's just looked at as an issue that can be resolved through the court system, and people are just referred to go get a protective order, as opposed to making a police report at that time. Well, that was at least my personal experience, and I know the experience of many victims that we've worked with. So that's.
You say they didn't make a police report when you called them?
Mm-hmm.
They came out and nothing was done as far as writing up an incident report. Well, they violated the law.
I understand, and as an advocate, because I know my rights, I've been able to go to the police department and say, I require a police report, I need a case number, and that's what I tell victims as well, because many of them come to us without a police report, even though they've called police.
All right. Questions of members of the panel? Yes. Yes, sir.
Thank you, Mr. Chairman.
Mr. Fryer.
Can you walk us through the process for getting a protective order, the due process protections through that process? I've seen it once,
Okay.
but I'd kind of love a walkthrough of how that happens.
Sure. So in Georgia, a person can go to their local courthouse and request a protective order. There has to be a petition completed, and many times the local domestic violence organization will help in that. It depends on the community, like how that's handled. But basically, the petitioner will go and explain why they are seeking that protective order, and the judge may decide to issue a temporary order. Sometimes judges want to hear from both parties. Like I know there are cases when both the petitioner and the would-be respondent show up at the same time, and the judge hears from both people that same day. If the judge feels that there is enough to grant a temporary order until a full hearing can be had, then that petitioner will receive the order, which then expires within 30 days if it hasn't been served. And then they'll have the hearing to come back. If the respondent has been served, then the respondent should also be there to answer any allegations in the protective order. And then the judge makes a decision on whether or not to grant that order for a year, typically. You're welcome.
Further questions? We appreciate you being here today. Thank you for your input.
Thank you for the opportunity to speak to you.
Yes, ma'am. Mike Williams and Mr. Stanley, Hayden Stanley. Come on up.
Do you have an extra copy of this you're working on?
I can give you one.
Thank you very much. My name is
It's not
Hayden.
working off of, this is a potential sub, but we
Yes,
still
sir.
have the Holcomb bill in front of us.
Yes, sir. My name is Hayden Stanley. I represent the Georgia Apartment Association. Mr. Mike Williams is an attorney that his entire practice is apartment law. A great deal of that is focused on landlord-tenant issues. We have, from last year, worked with Representative Holcomb, the advocates, and other legislative interests in crafting this bill. The version that we testified 2 weeks ago in subcommittee in support of was LC ending with 7803S. My understanding is that this section 1 largely reflects that, with the addition of the information that you are discussing about police reports. We, after having worked with the sponsors of the substitute that we discussed a couple weeks ago, are supportive of that. We're comfortable with whatever you do in that regard, but we're appreciative of all of the collaborative work that's gone in. We represent the apartment industry, and I recognize that while our professionally managed and owned properties may take a different approach to this than every
Individuals.
landlord in the state. Yes, sir. We recognize that.
Yes, sir.
And then perhaps later there's additional sections that we're interested in. We'll talk about that at any point.
Just go ahead and talk about it now. That's on section 3, I believe. You're looking at the substitute that I have. I don't know if the other one contains it or not. I don't know if it does. I don't think it does. This is the section 3. Yes, sir. That's on 7892S.
Yep.
You got 78. Look at on page 3, line 90. Well, starts 92.
Mr. Chairman, I believe it.
I'm sorry.
The earlier page.
I'm sorry. It's earlier.
Yes, sir.
It's section 2. Section 2.
With your permission, I'll ask Mr. Williams to briefly talk about the issue that we're trying to clarify in the law.
All right.
Which is unrelated to the domestic
Yes,
violence
sir. Excuse me.
provision.
Good afternoon, Mr. Chairman, everyone. Thank you for having us here. This portion does not change the law in any way. All it does is clarify the law. To kind of walk you through the process of how, and what this relates to is the security deposits. The way this works is, and the way the law reads, is that when a tenant moves into the premises, a move-in inspection is performed if you're going to collect a security deposit. And obviously the purpose of that move-in inspection is to itemize any damages to the premises at the time of move-in, so that way you have a comparison at the time of move-out. The way it works is the landlord's present, the tenant's present, the move-in's performed, the move-in is signed off. Some of you have probably seen the forms. They're about this size. They're split down the middle with the move-in on the left and the move-out on the right. And that's what the first section of 33A is all about, which is not included in here. The problem is at the time of move-out. And the way it works is within 3 business days from the date that the resident moves out, the move-out inspection must be performed. 3 business days. Ideally, what the landlord and our professional landlords want is they want the tenant present, because then you can go through the move-out inspection together. You can itemize the damages, and you can have the tenant sign off or the refusal to sign off. That's covered for under the law currently. The legislative intent, this law goes back to 1976, was always that within 3 business days the list is compiled, meaning you write down every item of damage with the estimated damages on the move-out inspection form. Nowhere in Section B, which is now B1, contained on line 64, was there a requirement to send the notice anywhere. It was basically the purpose of compiling it. And the reason why the 3 days is significant is because you want to do it in close in time from when you get possession back, so that nothing has changed inside the apartment. The problem has been is there's a little bit of ambiguity in the law under, and if you look under on page 3, lines 82 through 84, and it says a tenant who disputes the accuracy of the final damage list, and it says given pursuant to subsection B. Well, unless you're present for the move-out inspection form, you're not going to be given anything. It's going to be sent within 30 days as provided for in the next code section. So just so everyone understands that, under this next code section, which is section 3, within 30 days or 1 month from the date the tenant moves out, that move-out inspection must be sent to the resident. And it's got to be mailed to the last known address or the forwarding address. When it is mailed out, either 3 things are going to happen. The first thing is going to be the security deposit gets returned in full if there are no damages beyond normal wear and tear. The second thing that may happen is the tenant may have, let's say it's a $300 security deposit and there's $100 worth of damages. The difference would be sent to the resident with the itemized list showing why it was retained. The third thing that may happen is the damages may exceed the totality of the security deposit. Then the itemized list of damage is sent to the tenant, showing what the amount of damages is, and a lot of them send a separate form showing a breakdown of how it was assessed. At that point, the tenant can dispute it. They send letters. I address those all the time. We look at those closely, and at some point, if they find that if there's a dispute about the accuracy of that list, they can obviously file suit. Under section, on page 3, 82 to 85, the proposed language is changed to reflect instead of given, it's compiled pursuant to subsection B and provided to the tenant pursuant to 44-734. So there's nothing being taken away here. It's just a clarification. It's been done this way forever. Within 3 business days, performing the move out, itemizing the damages, and mailing it within 30 to the last known address. It just seeks further clarification.
What's been the problem that's arisen? The fact that they would not appear to go through the inspection with the landlord's representative?
There's a good portion that do not, that are already gone, or they've either skipped out or they're no longer present to do the move-out inspection.
So
And
as I
so
say,
you're stuck with doing it yourself.
So
with
as I say,
mailing.
what's the evil we're trying to correct?
Well, we're trying to correct, I mean, there is some litigation, some class action litigation that ensued. We're not trying to fix that. We're trying to go forward. That's really what brought this to light. And the argument was made that you have to give them the list within 3 days. So even if they're not present, even if you sent them the list within 3 days, they certainly couldn't come back and dispute it within 5 days because they wouldn't have received it. So it's never was the legislative intent. The intent was to compile the list, and all it's doing is seeking to clarify that we're compiling that list within 3 days.
And let me follow up what you said.
Sure.
It's brought to mind. You said there is some litigation pending.
Correct.
And if what we're doing today is not going to have any effect on that pending litigation whatsoever.
Not at all,
Because
Chairman.
I don't like to change laws to help out one side or the other with litigation.
Not at all. That litigation will keep going at where it's at. This is just to clarify it. It certainly brought it to light
Yes, sir.
because it was never treated that way in the past.
Okay, thank you.
Yeah,
Yes, sir.
I just was gonna say that understandably there'd be a question, why don't you just run your own bill? And we've been working on doing that, but in the interest of time and where we are in the session, that's how this came
Understand.
to be here today.
All right. Mr. Fleming.
Thank you, Mr. Chairman. I just want to make sure I understand what you're talking about. The change you need is in the sub,
In the Willard side, yeah.
in the Willard sub. Okay. All right.
Section 2.
Section 2. Thank you.
Any other questions? Well, we thank you both for being here today. Not to cut off anyone else, does anyone else wish to address the committee on House Bill 745? Yes, sir, would you come forward and have a seat and give us your name and who you represent?
Hi, Jeff Ledford. I'm with the Georgia Realtors, and mainly just want to express our appreciation for Representative Holcomb reaching out to us and allowing us to help him get this to where it's at now, and we are in support of this bill.
Okay, thank you.
Thank you.
Anyone else wish to address the committee? If not, we will close all further committee input, and the bill is now in the breast of the committee. Do we have comments from members of the committee? Mr. Holcomb.
Thank you, Mr. Chairman. Firstly, I want to personally thank you for bringing this forward today, and I want to have a discussion about the new requirement briefly. I'm not in favor of it, as we had a discussion earlier, and I'll explain why for the other members of the committee. I've done a survey of all of the state laws, and I think 28 states now have a provision that is similar to what we're considering here now for Georgia. And the bases for early termination and the policy interest behind that is to provide a mechanism for which a victim of domestic violence can terminate a lease early without any economic penalties that may keep that victim in a bad situation. What I would call the lowest standard across the country is what is represented with just the court orders, without the court orders with, in addition, police report. We would be, if we passed it in this version, we would be the only state that has a requirement for a police report in addition to a court order. There are states that have as low a standard as a co-tenant being able to write an affidavit, so without even having to go to the police or to a court period. And then there are other states that have options for counseling services or clinics to be able to listen to the advocates and then to put forth also a statement without even involving law enforcement, just to give the committee some sense of other areas. What is most compelling to me in terms of the requirement for the police report is in situations where the victim may be told specifically, do not call the police or you will be harmed. That concerns me. And without it, it would allow somebody to go to a court, swear under oath, and I think that there is a protection there because the individual would have to go to the court, swear under oath with penalty of perjury. And so it's I understand the view that one could misuse this to get out of a lease, and I'm not interested in helping somebody that's trying to inappropriately cancel a contract. But for those individuals that may have been specifically threatened, do not go to the police or I will harm you, without the police order requirement, this bill would give them the ability to go to court, get the temporary protective order, break their lease, and then get to a new place of habitation and to get out of that bad situation. So that's where I'm coming from on that, but certainly I will respect the will of committee, but wanted to have that known. And so I think also, Mr. Chairman, is I'm supportive of the other related issue. So at the appropriate time, I would make a motion off of the Willard sub to address the point that I just made, and I'd be happy to answer any questions.
All right. Judge Caldwell.
I guess a question and a comment, Representative. I literally have signed, I'm going to say thousands, but I can almost say that literally. And you said if they were told not to go to police, but they have to go to the court to get the order.
Correct.
And I have never had one to come before me, and I'm talking about literally hundreds, that the question was not asked, have you gone to the police? And at that time, if they had not, they were either called at my direction or someone else's direction. So I'm not belittling your point, but I guess what I'm saying is the police activity or the knowledge is going to come out anyway. Oh, it always did in my situation for 15 years. Because sometimes they haven't, as you said. But the question was, have you gone to the police? Did you make a report? Did somebody else make a report? So I don't see that as a problem from having dealt with it, because that question always came up. And if the person then said, no, I haven't been, then immediately I had them called or called a police officer, somebody in that type of situation, or certainly an administrative individual to call then whatever agency would have been involved to get that person some help. And of course then sometimes they, not often, they got up and did walk. So I'm just saying, I don't see that as the problem. I think that you'll see, and I see Judge McGarity back there. I think I'm not saying he's going to agree with me, but I'm sure he has signed lots of them, and the police are going to be involved at some point, in my opinion, or at least some knowledge of it.
Yes, sir. Thank you. Ms. Oliver.
I have used to do these calendars when I was a magistrate court judge, so I've done a few, not thousands, not hundreds, but I think it's totally appropriate that the judge ask, were the police involved? Did you call the police? What happened? But that's different from saying you've got to have the police report. The bureaucracy, and I'm going to use that word not in a disparaging way, but in the reality world. I wasn't going to do that. In the DeKalb County, to get a police report in our 800,000 person with 15 different police office, entities, law enforcement entities, it does relate to a bureaucracy. So I think you're absolutely right. If, as the judge myself, are respectful of you, asking about were the police involved is a way for the judge to make an analysis of the seriousness of what happened at that time. but the police report relates to more of a bureaucratic task.
Well, let me give you my insight on what I'm trying to do here. We're not talking about taking out the unilateral one party getting a civil order issued. That can still be done. We're talking about the cancellation of a contract as a lease. And all I'm pointing out is there should be something that addresses the need to have something back up that the incident has occurred other than just the statement of one individual who has a financial interest already involved with whether or not that lease is going to be canceled. And it's not talking about the 100-unit apartment projects that may be potentially where one of these come from, but people also have a lot of rental homes, small investment properties, and they're going to have an impact, a financial impact, as a result of this occurrence. And now they lose their tenant. They're put in a position of having to go out and try to make up that loss, whether it can be or not, how long it's going to take them to do it. We're allowing what is by law, and I don't know how many other situations like this we have in the law, but we're allowing by law a contract to be voided. And I think it's a serious step for the state to take as a policy where that is the ultimate opportunity given to someone, especially on just one person's say-so, who I say has potentially a financial interest involved in it. And I feel fairly strong about that point. Are there any other comments of members of the committee on this issue as to where we go with it? I'm going to ask Mr. Holcomb. Mr. Holcomb, do you then reject the proposal that I'm making for this matter to have the extra step of protection there that will protect everybody? To say you can still get your unilateral order. The question is the next step, which is I want to have my lease voided. Do I have to have something else to back that up?
My preference would be to not include the police report
Well, then you reject the amendment that I'm suggesting. You either accept it, yes or no. Simple as that. I'm not trying to put you in a hard position, but I want to know, it's your bill.
Yes, sir. I would prefer for it not to be included in there. Everything else I support.
All right.
With the exception of that, I would
All right. Okay, Mr. Kelly, you've got a hearing coming up tomorrow on another bill, and that's what bill is that? I mean, whose bill is this? One that Ballinger. Well, we're going to suspend consideration of this bill at this time by direction of the chair. Is there anything else to come before the committee at this meeting? If not, we'll stand adjourned.